This is Ask the Expert. I'm John Burgess, and our expert today is James Sanson, an attorney here in Santa Rosa. And James, today we're going to talk about bankruptcy and divorce. Can only one spouse file for bankruptcy?
That's actually a really common question I get, and the simple, straightforward answer is yes. There are advantages to only one spouse filing for bankruptcy, and there also may be certain disadvantages to only one spouse filing. Each person's factual situation may be different, so it's important to speak to an attorney to figure out whether one or both spouses should file.
What is the impact that bankruptcy has on divorce?
Bankruptcy could have a substantial impact on a divorce, especially if the filing spouse is seeking to discharge what the law refers to as a domestic support obligation, as generally speaking, domestic support obligations are not dischargeable in bankruptcy.
Well, and I guess the overall question is, should you hire an attorney if your ex-spouse is filing for bankruptcy?
I, of course, would say yes, especially if your ex-spouse is obligated to pay child support, spousal support, or some other type of property settlement agreement. With the exception of child and spousal support, the legal definition of domestic support obligation is very broad, so it may be unclear whether something you're ordered to pay classifies as a domestic support obligation or not.
Okay. James, let's go a little bit deeper on that question. And what can you do when your ex-spouse files for bankruptcy? Kind of walk us through what you're looking for.
Well, basically, when your ex-spouse files for bankruptcy, you should receive a notice of the bankruptcy filing. That triggers some very strict statutory timelines, and it basically spells out what you are required to do to protect your rights. The burden is on the non-filing spouse to protect their rights, and if they miss even one deadline, they could forever lose their protections.
Well, and certainly the next step is the determination of child support. How is that determined?
Simply put, child support is determined by a party's gross incomes, and it also takes a factor into how much percent time the child spends with each parent. You're allowed certain deductions off your income, and you should consult a knowledgeable family law attorney to basically determine what those would be.
Now, can child payments be reduced through the process?
Child payments cannot be reduced through bankruptcy. However, if a person has had a material change in circumstance, they can certainly file a motion with the family court.
Okay. Yeah, a lot of great information, James. To find out more, where do viewers go?
Go to jamessansonlaw.com.